Hey guys, welcome back to tonight's broadcast live stream. And I think we're streaming everywhere tonight. We got a lot of stuff to talk about tonight. So let's get started. Just double checking everything to make sure that we're good to go. So if you guys are joining us from Facebook, please go to this link here and give StreamYard permission to use your name. Otherwise, you'll show up as Facebook user, and I want to know who I'm talking to. So it's a good idea just to go and let them know so that you give them permission to show your name. And I don't think you have to do it every time, but you do have to do it the first time so that when you have comments, we'll know who's talking. Well, we want to do better than Facebook user. So, welcome, guys, advocates for justice, paralegal service. And we do a bunch of stuff. So, that's it. Welcome tonight. And I hope you guys are going to find some value in what we're talking about tonight. We're originally we're starting out, as you know, if you read the thing that I posted yesterday, we're going to talk about the dissolution of marriage package and kind of what we've done to it to make it a little bit smoother process for you guys that are using it and saving a whole ton of money. But before we get to that, we got something else that came up that we want to have like a little team meeting kind of a thing and talk about this other thing that came up today. So let me get everything in the right place here. And we will get started with tonight's practice. Now, the new thing we're going to talk about tonight. We've had a couple of people on our team that are facing this mental evaluation situation. And those of you who know a lot about me know that I have quite a bit to say about that situation because been there, done that. Only thing is, it took me 33 months to get back home when they started that crap on me. So I'm going to help you so you don't have to get yourself in that trick box of trying to get out after they deem you mentally incompetent because you're not doing what your attorney said you need to be doing or what the court thinks you need to be doing. I think in most cases, and not all, so don't get all riled up. In a lot of cases where this is the problem is people that either are using attorneys or had used an attorney and never fired the attorney because the attorney said they quit. Well, those of you who are doing well in this fight realize that the best way to tell when the attorney's lying is to see if their mouth's moving. So when the attorney tells you they quit, then their mouth's moving, right? So they try all kind of stuff to get past the program and help them get you beat down to where they need you to be so that you can go sit down and give up. That's what they like to see you guys do, is sit down and give up. But we don't have that option in this program. So yep. As long as you don't give up, you have a dang chance. Yes, you do. So tonight we're going to talk about the marriage dissolution and without a spouse. But before we get to all of that, well, a marriage dissolution without your ex-spouse's signature. That's what the marriage dissolution package is about. And before we get to the quick overview, because I'm going to do like a little quick overview to let you guys know how this package came about and why, and then we'll talk a little bit more about how you're going to use it and go down that path. So, but before we get started on all of that, I want to spend a couple minutes talking about this issue of the mental evaluation, the threat of a mental evaluation. Now, I have a lot to say about this. This just came up today, so I added these notes in so that we could just kind of touch base on it. I'm going to open up a new playlist and have it, you know, to discuss this issue because it's going to take more than one quick addition to the video to get you guys up to speed. But today we're going to talk mainly a quick overview so you know how to shut them down and stick some stuff in their face until you learn the rest of what you need to know. So that's what we're going to do here real quick. So the mental evaluation usually comes up in most cases with folks who hired an attorney and the attorney selling you out. And maybe you hired the attorney, but you didn't fire the attorney. Maybe you could even be an attorney that's not connected with nothing that you're doing right now that was doing something before or helping your dog crosses, that guy hit crossing the street or something. These attorneys are fraudulent. So you can't put nothing past them. And that's usually how it comes up, the mental evaluation. And I think it's ridiculous for them to go down this road. And I'm going to show you how to kind of what you need to know, kind of an overview. And the other thing too is that if you show anxiety and stress out in court, then they will try and use this because they want to break you. They want to break you by stealing your hope. And when you have an anxiety attack or go off and start yelling and being, some of you people know what I'm talking about. Okay. Those are the things that tip them off. And basically, while all they're doing is punching you some more while you're having your attack or while you're maxed out, punching you some more and kicking you so that you can give up because their process is fraud. And if you know how to attack them at the gate and keep them at the gate, they don't have a chance. Only thing they have is to try and make you give up. Oh, wait, they're doing the same stinking thing you're doing to their butt. You're making them give up. You're not going to court expecting the judge to rule in your favor on anything. At least you're not if you're on my team. We're not going to court asking the judge for anything. We ain't even trying to go to court. If you're using my products and strategies, your goal is to stay the hell out of court and make them give up and go sit the hell down. So, the mental evaluation. Now, before the court can order a mental evaluation, the court must complete what's called the cell hearing. The cell hearing is a hearing that was named after this doctor that was deemed nutty, and they named the hearing after him, and he didn't have to take the medication in the end. And we'll get to his story and how that all on a different video because it'll take a while and it'll get us off track. On this video, I want to just give you a couple of tools that you need to jam them up when they're addressing you with the mental evaluation thing. Hey, James Galley and Calvin, welcome to the stream tonight. And Calvin just bought the judicial foreclosure package. Way to go, Calvin. You will have what you need in that package to get some stuff done. So the cell hearing is a hearing that they have to have before they can force medicate you or send you for a mental evaluation or any of that. And in that cell hearing, you have a right to call witnesses. You have a right to present evidence to the court. You have a right to do all of the things that you should be doing in a hearing, except you don't have the right to do that stuff if you have an attorney, because the attorney's not going to tell you about your right to do any of that. And the attorney's going to tell you to go sit the hell down and shut the hell up. That's what they're going to tell you. Because the more you keep complaining and talking and doing all this stuff, the more they're going to think you're crazy. Yeah, that's how they do it. They told me the same crap when I was going through this, and I was mailing out all my stuff when I was appealing the forced medication order from the medical facility. They told me, dude, if you keep on doing this, they're going to think you're really crazy. And I said, they already think I'm crazy. You guys are stupid. And I kept doing it. And I ended up winning my appeal after I fired my attorney. So you fire your attorney, you have a chance. Think about it. They brag, the federal government brags all the time, they have a 98% conviction rate. Well, no, it's not a conviction rate. It's a plea rate. They have a 98% plea rate because they attack you, they jam you up, and then they back you into the corner, and then they threaten your family and all of this stuff to get you to say whatever they want you to say. Yeah. So it's not a conviction; it's a plea rate. So the way I see this is, if I don't have an attorney, I have a 98% chance of winning. Yeah, I know they're saying 2% chance. Okay, yeah, no, 3%, 2%. Yeah, but I see it the other way. And when I started on that program, I got myself out. So there you go. Yeah. So if you have an attorney, the attorney most likely has agreed to help them beat you down with harassment and mental evaluation crap. And if you have anxiety attack or high anxiety, I mean, most people do have anxiety about being kicked out of their house and living on the street. So, and I'm not saying you shouldn't have it, but you should not have it when you're dealing with these fools, because they will use it against you in a heartbeat. Now, and I'm just going to go here, okay, because I'm the coach. Most of this can be avoided by holding their feet to the fire, where the jurisdiction challenge with an affidavit or jurisdictional challenge with an affidavit, and keeping their butts at the gate by suing the state court judge as soon as the judge helps the attorneys get a free pass. This is the step that most people are missing in the program. They feel like when the magistrate judge, who doesn't have any business in anybody's case in the first place, without signed consent from all parties, when the magistrate judge comes in and says, "Oh well, blah 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 blah," they just like, "Oh well, damn, the judge said," the judge is full of crap, and the judge is helping them. Come on now, you guys know that already. You got to be kidding me. The judge is not going to help you do anything, because the judge is part of their system that they set up. And their system is structured for arguing. And when the arguing's done, the judge gets to help them. It's simple. And that's why we don't go down we go down the path with stuff they don't want to argue about, and the stuff the judge don't want to help them about. And the trick here is to sue the judge when the judge helps them. All of these people want to file a appeal. Are you kidding me? So you're going to file an appeal and ask their buddies to help you some more while they're loading your stuff out, while they're moving your stuff out on the stinking yard? No. I think I'd rather just sue the judge. If the judge don't do the right thing, why appeal it? Well, you should just sue them. And that's what we're doing. These corporations, that's what we're learning right now. These corporations don't give a crap about anything unless you figure out a way to cost them time and money. So we want to do that. We want to cost them some time and money. And we are not going to waste any time messing around with an appeal. So that's a waste of your time. So if they are trying to jam you up for a mental evaluation, what you need to do, what I would suggest that you do, is you must move to dismiss the attorney or the court's order demanded a mental evaluation on the grounds that the doctor doing the evaluation is not competent to evaluate you. Okay. Now, I know this sounds crazy, but stick with me here for a minute because it's going to get even worse. Yeah. So, how you going to challenge the doctor when the doctor is doing what the doctor is saying? Yeah, well, I look at it like you can do one or two things. You can listen to the doctor who's getting paid by you know who, or you can challenge the doctor's butt and get what you need on the record to sue them if they go ahead and do this without. Yeah. Okay. So the doctor is not competent to evaluate you, and the doctor's job is to assess your mind. And now I know this firsthand because this is what I used when I was in this situation. When I told the doctor this stuff, he was pissed. Yeah. Anyway, I won the appeal in their order to force medicate me, and so he couldn't medicate me. So, and I didn't have time to sue them while I was locked up because they were saying I was crazy. Otherwise, I would just sue them. But if I'm not locked up, that's what you're gonna do. If you're locked up, you got to do what you got to do. But hopefully, if you're watching this video, you can prevent yourself from getting locked up. That's the whole idea here. So the doctor job is to assess your mind. But here's the problem. The doctor does not know where your mind is. Think about it. If the doctor cannot tell you where your mind is, how can he or she be competent to evaluate it? This is simple. And just a quick overview and this is just a quick overview of how to get control of this mental evaluation BS before you find yourself locked up. Yep, challenge the doctor and ask the doctor. Call them, have them. I would have if they're going to have a hearing for you. I would have the doctor show his butt out and ask the doctor, "Hey, where is my mind? Are you competent to evaluate my mind if you don't know where my mind is? And if you do know where my mind is, can you tell the court where my mind is?" And that's pretty much could it be that easy? Yep, this is a simple overview and what you need to do to get control of the mental evaluation situation before it becomes a liability for you. Now, I'm going to have a new playlist, Defense Against Mental Evaluation. I'm not sure what I'm going to call it yet, but this is going to be the first video in it. And I'm going to go over other things. Actually, I'm going to break it down, and we're going to talk about the cell hearing, how it came about, how they came about this. And when you understand what they use this mental evaluation for, you'll see that it don't apply to what they're trying to do right now to most people. And it can't be done. Well, I'll say it can't be done because people give up and they think the judge is the one running the show. But legally, it can't be done without consent from both parties. So there you go. Most of the stuff that people don't realize when you're getting arrested and they have you sign this, they take your stuff, they have you sign that, they take your belt, your shoes, you got to sign that. Well, when you're signing all of that crap, you're agreeing to what they're doing to you. People don't realize that. So the mental evaluation situation is something that you can take control of if you are not living in fear and freaking out. And I explained to you guys how to do that. And what you want to do is get things on the record. I mean, if you're using the program right, the program is going to help you attack the attorneys whenever they get in your face. And that's or the judge, the bar members. We'll just call them the bar members because that's what this is all about. Attacking the bar members when they try to help the other bar members take your stuff. So one of the things too is that I think a lot of people discuss things with the clerk that they shouldn't be discussing. Personal things, things about their health, the reason why they couldn't make it to court, what happened. All There's a lot of stuff that people discuss with the clerk. Hey, feud 198. There's a lot of stuff that people discuss with the clerk that they shouldn't be discussing. And these things give with the clerk the tools that they need to call their attorney and tell them, hey, she's about to have a nervous breakdown. We need to hit her up with a mental evaluation and see if we can make her crack. Yes. Yeah, absolutely. So the only thing folks in my program should be discussing with the clerk is the information in the jurisdictional challenge with an affidavit, or the information in the jurisdiction challenge with an affidavit, or the information in the lawsuit package that you shoved in their face. I have people call me and then message me, hey, I got a hearing and how do I prepare for it? I'm like, are you kidding me right now? So you should be prepared for it already. If you understand the stinking documents that you filed, then it's a wrap, because that's the only thing you want to talk about. They didn't respond to your stuff on the merits. They can't, because they're lying. So if they didn't respond to with by counter affidavit, they should be moot and there ain't nothing to discuss. But if you let them trick you into having a hearing and discussing the things they want to talk about, then they're going to want to talk about setting you up for payments. And some people are happy with that because I'm not getting kicked out. I'm getting to make payments again. Yay. Well, what they're finding out is that, yeah, they're making payments, and those payments that you make, they take them and they put them and they say these were payments that you are behind on, and they still foreclose on your butt and take your property from you while you're happy that you're making payments. People don't realize that a lot of times that whole Zoom hearing is designed to get you to agree to make payments. And when you do, you're letting the judge know that there was a contract and that you are the one that didn't pay like you were supposed to, and that they have the right to take your property right now. This is why you should not talk about anything except what's in your documents you're shoving in their face, because you don't know what they're making you talk about or why. See? So you start talking about the payments, and next thing you know, you just admitted that you owe the payments. And yeah, so anything you do after that, yeah. So there you go. That's how that rolls. The other thing is you never want to let them see you sweat. When you go to court to file my stuff, to file the stuff that you got, to file your stuff, you don't want to, oh, this is crazy. You can't, oh, no. Oh, dude, my legal team said that this was going to work just fine. And that my legal team said that this whole document was structured according to the filing requirements for the statute for my state. So if you guys are saying there's a problem with it, I'm going to have you write a note down there or something and tell me what the problem is. So, and the law that you're citing that I'm violating, or the statute or whatever, even though statutes aren't real laws because they don't have what's necessary to be a valid law, don't even get me started. You should never let them see you sweat. And I don't care if you don't know what the hell you're doing. One of the things they say, and my wife's in cosmetology, they taught her this. And you learn this in sports too. You want to fake it till you make it. That's what you do. You fake it till you make it. And so when they're talking crap and giving you a hard time, you got to jump. Oh, no, dude. I researched this stuff that my legal team put together, and I don't know what you're talking about. These rules that you're telling me I need to follow, they're not the rules in the federal rules of civil procedure. Those are the rules everybody's supposed to be following, right? So I didn't know where the local rules came from, but they're not connected to the Constitution or to anything else except a corporation. So I don't have to follow them because I'm not part of the corporation. There's just some crap you guys can talk. There you go. Never let them see you feeling like they won. Never. You always want to act like you got this under control. Yep. You always want to act like you got it under control. So I remember one time when I got hauled away, the first call that I made that I actually from the jail to it was to my brother in Arizona. For some reason, the call went straight through to him, and I wanted him to give a message to my daughter. And so I told him to call my daughter and let her know and give her a message. And the message that I wanted him to give my daughter was I wanted him to tell my daughter not to worry because I had them right where I wanted them. Well, they had me locked up in jail, but I was talking from the jail phone and I was saying I got them right where I want them. And of course, my brother just died laughing, and when he told my daughter that, she cracked up laughing too. And the goal was to let her know that I'm fine, I'm not freaking out, just relax. I'll be home in 33 months. It's gonna take me that long, but I didn't want to worry. And man, I tell you what, they brought that up in court one day that I was talking crap, that I had the nerve to tell the prosecutor to tell him I had them right where I wanted them. And they was making a big deal about that in one of the hearings one day. I was about ready to bust up laughing. Yeah, so that's how you got to do it. You got to talk crap, make them think you're crazy. But I'm showing you how to take care of the crazy thing. Okay. Hey, Neville. Welcome to the program tonight. Okay. So you will learn that this is the only way they have to fight back with this crappy stuff that they're doing, trying to do a mental evaluation and trying to trick you into to doing an appeal because they need more time to beat you down. So they'll tell you you need to appeal this, and they'll have the clerk tell you we're going to do this and we're going to do that, and the clerk can't do any of that stuff. But the clerk can lie to you and get you to believe that they are going to do it. And if you don't jump up in their face and act like you ain't having it, then they'll do it. That's kind of what they do. Hey, we're going to do, okay. Oh, I don't know what I'm going to do. Okay, great. Do it. That's how they tell you. Yeah. So, a quick overview on the dissolution of marriage package. Okay, we're going to change subject now. So, you guys keep up with me. Okay. So, this dissolution of marriage package was structured for a very close family member. And we studied their system, and this should what we came up with should work for like $10 for placing it on the public record. That's it, to get your marriage dissolved for $10, and you're going to be using the same process they use. And so what we did was my people went down and placed it on the public record, and then they went back the next day to look at it. Well, when they pulled up the public record on the computer in the county recorder's office or wherever the courthouse, wherever it was, they pulled up on the record and it showed that they were married on this day, and it showed a copy of their marriage license and all of that. So when they filed the dissolution of marriage, they went back the next day to check it and pulled it up, and it showed that the marriage had been dissolved the day prior. The day prior had been dissolved, and the document that I structured to dissolve the marriage was filed in the public record right next to the marriage license. That's what tipped me off and gave me the idea for this package. I'm like, what the hell? Are you kidding me right now? Okay, so in order to make the marriage legal, they're going to file it on the public record. All that mumbo jumbo that they do with the marriage license and all that, that's all just at the end of the day, to make it legal, all they're going to do is file it in the public record. So you could make it unlegal by doing the same stinking thing they did. Now, I'm just throwing it right out there. If you guys have been doing your homework and doing the documents yourself and you can do this yourself, then that's great. I'm telling you what you need to do. If you need help, then you can go to the link that I'm going to post here in a little while and get the document package that you need. And I beefed this package up and included the lawsuit that you would need to file against them if they try to deny placing your document on the public record. Now, I had one person in South Carolina or North Carolina, one of the Carolinas, that went in and made some kind of comment about the divorce. And once the D word came out, they was freaking out. And they started telling her she had to go do this and do this. And they actually refused to file her stuff on the record. And that's when I came up with a little bit of addition to the package, because I like for my stuff to just So the public record showed the marriage license, and the public record showed that the marriage had been dissolved. And my people didn't have to pay all those attorney fees and court fees and be in the judge's face and go through all of that rigmarole. Now, this package will provide you with the documents you need to place, not file, place in the public record for $10. Well, the package is more than $10. The $10 is what you have to pay to place it in the public record. Keep up with me. So, to place, not file in the public record to dissolve your marriage. Now, you will be utilizing the same process the government uses to make the marriage legal, posting your dissolution document in the public record. And you will pay the $10 for them to place your dissolution document on their public record. And like I said earlier, you must be very careful not to use the D word, because you're not trying to get a divorce. You're just dissolving your marriage. To get a divorce means you have to pay the attorneys, and you have to pay the court, and you have to jump through all them hoops that they do while they're ripping you off. Okay, we're not doing that. So my marriage dissolution package will end the marriage without the signature from the ex-spouse. Ex-spouse, huh? You like that? I already got you in the package. Without a signature from the ex-spouse, without an attorney in your face, without a court hearing, without a judge up in your face, and without draining your bank account, paying attorney fees and court costs. Yeah. So if you know someone facing this problem, you should have them check out this package. I reduced the price down for the weekend sale to $200. It started out at $5 and it marked down to $3, and now I'm marking it down to $200. I'd like to see some people use it and leave me reviews and mention the marriage dissolution document. As a matter of fact, if you leave a review, please mention the package that you're using, that you're reviewing, or whatever, so that people understand which package or whatever, and then they can even ask questions on the review if they want about the package, or see your name and ask you questions in the Facebook page or something if they want to. So if you could be specific when you do leave a review and let everyone know what product that you're using. So you guys know how I roll. I don't fool around. So this package is on sale. Well, I was actually going to leave it at $300, but I knocked it down now. So it's down to I think it's $200. So if you guys are facing this situation, you probably should jump on that and get that package. So in this program, with this package, you're going to be challenging the validity of the license, of the marriage license, based on the fact that the state failed to fully disclose the terms of the marriage license contract. So you're going to dissolve the marriage, not based off on what the other person did or what you didn't do or did or any of that. You're going to attack the government for the fraud behind the license. Fraud. The state did not disclose that the guarantor of the license is a privately owned corporation, and the state did not disclose that licensing with them was not necessary for you to be married. State did not disclose that if you requested a license from them, you were declaring yourself incompetent. The state did not disclose that you were signing over possessions of your future children to the state as collateral. Yep. Yeah, this has to do with them taking out Social Security number on your kids and a bunch of other stuff. And that's for a different video. But if you stop and think about it, if the state is the guarantor of the contract, anything that comes out of the contract is going to belong to the state. And in contract law, there is no signature if full disclosure is not given with the presentation of the agreement. Thank you, Lori. So if they didn't disclose all of this stuff, and the funny thing is, when I was doing this research with uh, my people called down to the courthouse to find out who the guarantor of the contract was, because we didn't know who was the guarantor of the contract. They came up with the contract. Back in the days, people would get married and they would keep whatever they had for what the marriage in their Bible. And it wasn't their fancy marriage license and all of that. So there was a time that people got married before they started charging people all of this. And we'll kind of go over that down the road just a little bit. So the goal for doing this research was to find a way for my family member to divorce without having to pay attorney fees and all of that stuff, go through court and all of that. Most people know that when you're going through this situation, the tie goes on the side of the woman. Now, no offense against women, but that's just the way it is that I've seen. The tie goes on the side of the woman. So it's a lot harder a battle for a man in this situation trying to make it through this. Now, here's the thing. This package works if people aren't being stupid fighting with each other. If you can figure out, if you got property to split up, if you can figure out something, you write a contract, you both have a copy of the contract, you both sign a contract with a notary or whatever, all of that, and you don't need a judge. You don't need anybody else in your face. For the people who can't do this or have too much whatever, then you need a judge, and this is not going to work for you. But for the people who can figure this out, you don't need to spend thousands of dollars with attorney fees for them to fill out court forms that in the end, none of that crap that you talk about in court, in the end, they're going to place the final document, bam, on the public record next to you. So basically, you're going to be using the same. So how it works is basically you're going to be using the same process they use to make the marriage legal, to make the process unlegal, and there's nothing that they can legally do to stop you. Now, this process works best when there's no disputes that the judge needs to rule on. Like I said, if you guys can figure out something, you don't need to have a judge in your face. So the competency issue, the only other reason that it would be lawful for two consenting adults to be married is if they were otherwise incompetent. And therefore, couples go to the state and ask for a state license when there's no reason for them to need to get a license other than just being incompetent in the law. And a lot of this is stuff that they have indoctrinated us to believe that's not true. And there are a lot of things that's not true. And I'm sure some of you guys are finding out some of those things in this program. So No one must ask when the bride and groom are competent to be married without a state license, and that state grants a license, then who's responsible for the marriage? It's the guarantor. The state's responsible for the marriage. And now one must ask, when the bride and groom are incompetent to be married without a state license, and the state grants the license, who's responsible for what is created out of the marriage? Now, this is the kid thing that we were talking about. So did you get swindles? First, you must learn what happened. So in the past, in past times there were no licensings for marriage except in cases where people was unlawful to do otherwise. For example, in the biblical laws, in the beginning, biblical laws forbidden interracial marriages. So the statutes of the nations, which were based on biblical law, so prohibited interracial marriages between interracial people of different races. So, if the white person wanted to marry a black person or Indian person, they were by statute were required to get a license. So marriage records were kept in the family Bible. Then in the county clerks in the county recorder's office. So then statutes were created allowing anyone desiring a license to attain one. And we didn't need that, but they were created for us because those statute creating people really, really care about us. Okay, then churches were used to help convince people to use the marriage license as a manner of recording the marriage. Now, over time, people began to believe that licenses are required by law, even though they were otherwise incompetent. It's ironic that the documents typically used to begin the marriage is the same document used to by a corporate state to remove your children from you. And nobody ever warned you because the government employees were just doing their jobs. So in contract law, there's no signature if full disclosure is not given at the time given with the presentation of the agreement. And in this case, the marriage license, if you use one, you were likely not informed that the guarantor license was a private-owned corporation and that the licensing was not necessary for you to be married. Yeah, we went over those. So if if you want to get a divorce and but are stressing over the cost of filing for a divorce, attorney fees, and all the ugly litigation process, maybe your ex is crazy and you just want to do it without the drama, then I have the simple solution for you. So the marriage dissolution document, the benefits of using our document to get your marriage dissolved are: there's no extra cost outside of purchasing the package. There's no attorney fees or interference from the court. Theoretically, I mean, they may try to block you a little in the beginning, but you got what you need to slap them in the face with that. And if you're really serious about it, if you use the package, you could put the lawsuit together as a notice of claim. You just change the title to notice of claim or whatever for $5.5 million for them blocking you from doing whatever, and have it ready. And if they give you any crap about filing your document, then you want to hit them with the notice of claim. And the reason the notice of claim is important is because in their corporate rules, they like to give you 30 days notice of claim to allow you to do the right thing before you actually file your lawsuit. So when you file your notice, when you send them your notice of claim, it's not filing it, you're just sending it to them. I would serve it to them so you have verification that they received it. That starts the 30-day countdown that they have to do the right thing before you actually sue them. And if you're not about to get kicked out of your property, it's good to do that and give them some time to figure out how they want to do this and not have you on the record kicking the judge's butt, because that's where you're headed if you're in my program. If you don't kick the judge's butt in state court and they allow you, and if you don't jump on the judge in state court when the judge helps the attorneys, then you're kind of shooting yourself in the foot. And the other judges are not going to be in a big giant hurry to help you overturn another judge's ruling. You have to attack the judge with the lawsuit, file the reconsideration package, objection, the motion for reconsideration, and then your notice of claim. And yeah, you have, and then your motion to recuse the judge. Now, the recusing of the judge is what is like the big key to this. Because when you file your lawsuit against the judges have conflict of interest and can't continue. When you recuse a judge after you file your lawsuit, the judge has to go sit the hell down. I don't care what anybody says. And the judge has to go sit the hell down, and they need to find another judge. And that's the beauty of the strategy that we use. And now the new judge is looking at all of this and realizing that as soon as he or she signs her name on the thing, she could be in the same position. Because basically, anybody that's going to help them steal your property, you need to be slapping in the face. That's the way we roll. So you will not need agreement. You will not need an agreement from the soon-to-be ex. So, because you won't need them to sign it. Remember, you're not dissolving the marriage because of anything the ex said or did. Theoretically, hypothetically, you're attacking the government for making you sign a contract that they didn't disclose. Yeah. So remember. So now it takes the pressure off all that. So you can take control of the situation today and move on with your life. And then the last benefits, you can stick it up in your ex's face. If they've been a pain and if they've been a BIT to you, you can stick it up in their face. So now you can get out of the marriage without an attorney, without court hearings, without draining your bank account, and without signing and without the signature of your spouse. So that's pretty cool. I'm going to open share the share window and share with you guys. Yeah. So here is the link to the package, the marriage dissolution package. And I'm going to open up the share window. And show you guys what it looks like. We're going to turn that off. I'm going to hide that. So this is what it looks like. And you can see that I got it marked down to $200. And we're going to leave it there for the rest of the weekend. And it just tells you a little bit about it. And then here's the description. And the description, down here underneath the description, I'll tell you what you get. And then there's a little video here. And I'm working on a new video that I'm going to post on here with the update stuff on it. So we'll get that done probably tomorrow. And what I'm trying to do is post the instructional video on the product page of each of my products. So you can watch the video before you make a determination that you want to get in the program. And this way you can see what you need to do and all of that. Because my program is not for everybody. Okay. So there's a link to the marriage dissolution without the spouse's signature. And you're welcome, Lori. I hope I gave you some tips that can help you tonight if you're facing this uh, mental evaluation situation. So that's all the value I have for you guys tonight. I want to thank you guys for allowing me the privilege of sharing your time. And I will see you guys sometime next week. One of the things I want to talk about, actually, I was going to talk about today, but I changed and decided to talk about the the mental evaluation thing because I think that's one of the things that they're going to be using more often to try to get people to fear themselves over into the corner and sit the hell down. So we might as well learn how to take care of that. And believe me, I know how to do it because I'm sitting here and I'm not taking no medicine. So thank you guys for sharing time with me tonight. And I will see you guys in the next video.